Hello and welcome to the Personnel Today HR podcast brought to you by Deal. Hire, manage and pay anyone, anywhere. I'm Rob Moss, editor of Personnel Today, and I'm joined by our regular contributing editors Joe Faragher and Adam McCulloch. Welcome both.
Hi.
Hello.
And we're very pleased to welcome once again our employment law expert, Darren Newman. Welcome, Darren.
Hi, Rob. Hi, everyone. Thanks for having me.
Each month, we look at some of the most significant HR stories of the past few weeks and examine the implications for HR practitioners and employers. In this month's episode, we're looking at fire and rehire and what reforms in the Employment Rights Act mean for HR. We'll discuss artificial intelligence, and in a rather meta section of the show, free from any AI input, we'll examine whether AI could be the answer to AI. And we'll discuss Reform UK's plans to repeal the Equality Act. This comes after the party's new equality spokeswoman, Suella Braverman, said the UK was being ripped apart by diversity, equality, inclusion, tokenism and victimhood. But before any of that, a message from our friends at Deal, sponsors of the Personnel Today HR podcast. Deal is the all-in-one people platform for modern HR teams, bringing hiring, onboarding, payroll, performance, offboarding, and more into one global system so you can focus on people, not paperwork. Serving over 150 countries, Deal simplifies compliance and helps HR teams move faster. To see what hiring without borders looks like, visit deel.com/personnel to book your demo. That's deel.com/personnel. Okay, let's get started. Reforms to fire and rehire, or to give it its less catchy, more formal name, dismissal and re-engagement, are in the pipeline for January 2027. We all remember the scandal that occurred in 2022 when P&O Ferries dismissed 800 staff to replace them with cheaper agency workers. Since then, the previous government introduced a statutory code of practice in 2024, setting out how employers should behave when seeking to change employees' terms and conditions. However, the Labour Party is going further with measures in the Employment Rights Act. And Darren, would you say that some HR professionals mistakenly believe that the new fire and rehire protections don't really apply to them? They'd never be that evil.
Yeah, I think there's a real problem with the way this issue has been framed by the government, because they keep talking about unscrupulous fire and rehire tactics as if the only employers who ever go down the route of eventually dismissing and offering new terms and conditions are doing it out of some sort of evil conspiracy to make more profit while screwing the workers as much as they can. And when you look at how the government assesses the impact of this, they think the impact is going to be quite slight, because very few employers, they say, go down the route of fire and rehire. And I think all of that just massively misses the point of what this law actually does, because what we're talking about is how an employer can seek to change terms and conditions that are in a contract if those terms and conditions no longer suit the circumstances or suit the business. And what we'd always say as lawyers when we're talking to an employer is, well, first of all, you've got to get agreement. So a contract is a legally binding agreement, so people need to agree to the change. Sometimes that's done collectively through a union, sometimes that's done individually with employees. What happens if you can't reach an agreement? What happens if you propose a change to the contract that might be a perfectly reasonable change and the other side doesn't agree to that? And the route has always been that the ultimate position that the employer would take is to say, well, in that case, I'm sorry, but the contract we've got no longer works for us. So we're going to terminate it. We're going to terminate the contract we've got with you, and we'll offer you this new contract that's got the changes in we need, and you can choose whether to accept that new contract or not. That's what fire and rehire is. It is normally, when it happens, the last resort that an employer gets to after it's gone through a process of trying to get an agreement to a variation in contract. And if you take that option away, which by and large is what the Employment Rights Act does, there are very limited exceptions, but it would basically make it automatically unfair to terminate a contract because the employee won't agree to what's called a restricted variation, and we can get into what restricted variation is later. If that's automatically unfair, then what's an employer to do? What does it do when it gets to the end of that negotiating process? It literally can't do anything, as far as I can see it, or it certainly can't do anything that's going to be lawful.
And when you say automatically unfair, that you're talking there about how a tribunal might deal with a claim.
Yeah, so at the moment, if you propose a change in terms and conditions and the employee won't agree to that, and so you terminate the contract, that's going to be a dismissal. That's a dismissal even if you offer re-engagement. It's a dismissal even if the employee agrees to the re-engagement and accepts the new offer. You've still dismissed the employee because you've terminated the contract of employment. And so the question is then whether that's fair or not. It's been accepted for decades that can be fair. It's one of those things that we put into the category of some of the substantial reason, which is a very handy category to have. But basically, refusing to agree new terms and conditions can be a fair reason for dismissal. The tribunal then has to decide whether the employer has behaved reasonably or not. And it's got standard set of things that it looks at in deciding whether the employees behaved reasonably. How strong is their business reason? Did they engage in proper consultation? Have other people agreed? So, for instance, if you make this offer to 100 people and 90 people are perfectly happy with it and 10 people object, are you really going to let those 10 people stop the whole process from happening? All of those factors get taken into account. Under the new law, none of those factors would count because it would be automatically unfair. So necessarily what this law does is it takes a dismissal that currently a tribunal would say was reasonable, that the employer was acting reasonably, and it deems the employer in those circumstances to be acting unreasonably. And I don't think people have fully taken on board the implications of that.
You mentioned restricted variations, because when the Employment Rights Bill was first laid, these didn't exist. This came in an amendment last summer, didn't it?
Yeah, it was originally drafted as any variation in the contract. And we've got to remember here, we're not talking about making it unlawful to vary a contract. We're talking about dismissing an employee because they're refusing to agree to a variation in a contract. And the kind of variation that you would bother to dismiss an employee for, if they don't agree to it, is normally going to be a reasonably significant variation, right? You're not probably going to go down this route if it's an incidental change that no one's really going to care about. But nevertheless, the government ended up excluding certain kinds of variation from the scope of this. They came up with a definition of restricted variation, which is so long that it's almost easy to think about things that aren't restricted variations. So a restricted variation is basically going to be anything to do with the pay that people get, the number of hours that they work, and the holiday and the time off that they get. And what's excluded from that, what's not included, is, for example, the location of work.
Right.
So if what you're doing is changing someone's location, so let's say, for example, to pick a completely random example, you're moving a civil service department from London to Darlington, and it turns out that many of the civil servants don't have a variation clause in their contract that allows you to do that. So you've got to propose the change, and if they refuse to agree, you would have to dismiss and re-engage them in a new contract in Darlington. That won't be illegal, or at least it won't be automatically unfair. The question will be whether the employees behaved reasonably. So I'm sure the government very selflessly introduced that change to benefit, industrial relations generally, and not just so that it can make its own variations to civil service contracts. But, so location isn't included. The content of a job, slightly oddly, isn't included. So if you were just changing someone's job description and you were doing that by contractual variation, a refusal to agree to a new job wouldn't be something that would trigger an automatic unfair dismissal. But if you accompanied that with any sort of change to pay, then it would.
Right. Okay.
So it's a slightly odd concept. We've got this restricted variation. I think it's going to catch people out, and it's going to get more complicated because the government's just launched a consultation on finessing the definition of a restricted variation to exclude things like benefits in kind and certain shift changes. So what that's going to mean, if the government gets its way, is that if you were proposing to remove someone's company car, that wouldn't be a restricted variation, and that could lead to a potentially fair dismissal and re-engagement. But if you were proposing to reduce someone's pay by £10 a week, that would be a restricted variation, and that would be an automatically unfair dismissal. Shift changes are also going to be excluded, we think. The government is quite open-minded in its consultation, but this is their proposal. The idea would be that if you changed the time that someone was working from, say, the morning to the afternoon, that would not be a restricted variation. But if you reduced their weekly working by 1 hour, that would be a restricted variation. And if you change them from weekdays to weekends, that would be a restricted variation. So, yeah, the legislation's got more complicated as time has gone on.
But there are exemptions, aren't there? Like if a business is about to go under, that type of thing. Is that the case?
I think it literally is if a business is about to go under. So there's what's called a financial difficulties exception. So if the employer, and you've got to think about different kinds of employers because there'll be different rules for local authorities and different rules for public sector bodies. But if you think of private sector, first of all, if they're facing a financial difficulty that in the immediate future is going to affect their ability to carry on as a going concern, then that will be an exception. And it won't be automatically unfair to dismiss. If you're a local authority and you're like Birmingham, currently under special measures effectively from the Secretary of State, so that commissioners have been appointed, then the provision won't apply to you. If you're a public body and financial difficulties mean you can no longer fulfill your statutory function, then the rule won't apply. But all of those are real existential threats that are applying in the immediate future. They're not, as the law would currently be, allowing an employer to make sensible commercial decisions so that a year from now it is in a strong position, right? It can't say we've got to make this change, otherwise over the next 3 years our business will decline. It's basically got to be saying we've got to make this change, otherwise the bank will close us down on Monday, right? It's that level of it's that level of urgency. And I don't think the nature of that exception has quite got through to people, but I think it's clear if you read the statute.
And what would you suggest HR professionals, business owners should be thinking about now in terms of preparing for this in January?
I'd certainly think if you've got any changes you're thinking of getting done quick, because it's going to be a lot harder to do them from January onwards. I think the other thing that employers are going to be looking at is variation clauses in contracts. So to what extent does your contract already have flexibility in it so that you can change things without needing to get separate agreement? So, for instance, you might have a clause in the contract that says, here is how we organize overtime, or here is sick pay, but we reserve the right to change it on giving reasonable notice, or, there are various different ways in which these variation clauses can be expressed. And lawyers, I think, are always a bit nervous about them because we think if we draft them too widely, you put something in the contract that says, well, we reserve the right to change any of this, then have you really got a contract at all? And there's implied terms about mutual trust and confidence. So we're not entirely sure how a very wide variation clause will work. But I think increasingly employers are going to be looking at trying to pack in the maximum variation into contracts already so that they don't in the future have to go down the sort of fire and rehire route. So we'll get more case law over coming years about exactly how far a variation clause can go and when it's a reasonable thing to operate.
I just wonder, Darren, if you've got examples of previous industrial disputes where the new law would really have made a big difference, where you think that presumably P&O ferries would have been one, although there's lots of maritime laws that kind of get in the way of resolving that. But what disputes come to mind where you think the law would have really helped? Well,
it doesn't have to be a big dispute. P&O ferries is covered by the new law. It's covered by a slightly different section of it, which says that it's going to be automatically unfair to dismiss someone to replace them with someone who is not an employee. So that's not necessarily about changing terms, it's about changing status, and that's going to be automatically unfair as well. I think that's less problematic. Think of an example of a redundancy case I was thinking of from the case law. So it's a real case. You've got a relatively small employer who employs a bookkeeper who works 35 hours a week. And they get some new accountancy software that means that they need her to work fewer hours. And I'm
Right.
saying her because the case I'm thinking of, it was a woman who was.
Yeah, I think
who
I
was doing
wrote
it.
about that case. I remember
I
that one.
think it's called Packman and Fouts, but check that, please, editor.
I will.
So there was a case where the employer wanted to go from 35 hours to 16 hours. They proposed that, and she said no. She refused to do that. They ended up dismissing her, and they would have engaged someone else to work 16 hours because they needed a bookkeeper for 16 hours.
Yeah.
And she was held to be entitled to a redundancy payment. That's what the case was actually about, because although their requirement for employees remained at 1, they had a diminished requirement for actual work from that employee. So the case is about, is this person entitled to a redundancy payment? It's not about whether the dismissal is fair or not, because it was basically accepted that what the employer did in the circumstances was a reasonable thing. Right? It had a reasonable business reason for what it was doing. It could explain why it was doing it. It offered her the job. It consulted with her. It tried to find a way to make it work. Ultimately, she said no. And they said, well, in that case, we just can't afford to have someone on 35 hours a week anymore. What does that employer do under this law? I can't really see a legal way for them to do anything. When the person says, no, I'm not doing it, they could make her redundant. But if they need someone for 16 hours and they replace her with someone on 16 hours, I think that makes a dismissal automatically unfair.
Right. Yeah.
If they make the offer to her and she refuses to agree and they dismiss her, aren't they dismissing her for refusing to agree to the variation? I think that would be an automatically unfair dismissal. But I think most people would say that that employer was probably behaving reasonably.
Indeed.
So
Okay.
why are we making that reasonable thing automatically unfair? I think it's really problematic.
When you mentioned variation clauses, does the ERA stop certain things going into those variation clauses?
Not specifically. I mean, one thing it does say is that once this law is in, you can't try to insert a variation clause and dismiss people if they don't agree to it. So
Right.
the insertion of a variation clause is a restricted variation, which gets a bit meta. There's nothing that I'm aware of that would prevent you having a variation clause other than a tribunal looking at whether the variation clause was a valid part of the contract, whether it was being operated in a way that undermined trust and confidence, whether it was too broad and rendered the contract too uncertain and needed to be interpreted in a very strict way. And I think that's where the battleground's going to be.
Okay, thank you, Darren. We're going to carry on with meta content. We're now moving to AI. The Personnel Today HR podcast is brought to you by Deal. Hire, manage and pay anyone, anywhere. Joe, what aspect of AI are we talking about this month?
So yeah, in very meta AI news, we published an article by a conflict resolution specialist called David Major. And he was talking about how AI could help HR do the heavy lifting when it comes to these higher volumes of workplace investigations and grievances that are coming their way. But the irony is that the higher volume in investigations and grievances is coming from AI. So essentially, people are turning to ChatGPT to draft a grievance. Some of them are even using it to prepare tribunal claims. I've recently seen this referred to as grievance slop, which is a delightful term.
Lovely.
And lovely for HR. That means they're having to spend more and more time manually going through these details. And then often they won't have any merit, or they might include details that aren't relevant to the case. Some of them are introducing additions to the claims, such as random bits of Canadian legislation and that sort of thing that just don't apply here.
Are there any stats to back this up, Joe?
There's no figures specifically on the use of AI in these cases, but we know that employment tribunal cases from individuals are going up. So these went up by a third in the 3 months to last September, and concluded cases went down by 10%. So there's lots of cases coming in, but resolutions are going down, so that they're not resolving as many. Also, ACAS shows that there are around 1.7 million formal disciplinary cases and 375,000 grievances each year. Then we've got the Employment Rights Act, which will bring a further increase in claims, likely for all the reasons we've discussed on today and also in previous podcasts. So there's a lot of work going on for HR already without having this grievance slop to mop up.
Whatever the statistics say, anecdotally from my colleagues in employment law, I pick up a lot of this. Everyone is seeing grievances that are written by AI, and it's generally you can tell when you start seeing references to case law in a grievance that's raised. That normally tells you that something odd is going on. Also, the length. I think if you judge a grievance by the number of pages the employees put in, once you hit 40, you start to think, oh, this is, and I've seen plenty where that's what happens. And it's really difficult for the employer because they've then got to pick up every point that's being made. And it's difficult to tell when the AI starts hallucinating, because sometimes they will make up cases. Sometimes they will write about the sort of thing that they expect to see because it's a predictive model. So it can be really difficult to go through these things with a fine-tooth comb. But yeah, it's definitely a key feature of how grievances are operating now.
It's definitely happening. So Joe, when we say could AI be the answer to this problem, what are we saying?
Well, David Major, who wrote the article, he's talking about the fact that even straightforward investigations, your average non-AI related investigation would take around 4 weeks to complete, and others can take months, as we know. So he says that AI could do some of the basic work, such as analysing emails and documents, looking at evidence patterns, looking for inconsistencies. There's always been an argument as well that AI could reduce the risk of bias because as humans, we're obviously very subjective about these sort of things.
Mm-hmm.
It could help reduce the time to resolution. So that helps you reduce any of those sort of nasty feelings of disengagement that teams might have when you know that somebody in your team's got a grievance and that's going through.
So what if the AI that's trying to spot this and help HR investigate and carry out some of these tasks, what if it gets it wrong?
Well, as Darren mentioned, the AI can hallucinate and it can make things up. It can make cases up, make up predictions. So you really need the human insight to this, because often these hallucinations mean AI isn't making sense. Also, employees are far less likely to trust a bot. If they know that a bot is making a decision about an important work matter, they may be less likely to report, reduces that psychological safety, that sort of thing.
Okay.
So essentially he's saying use AI for the heavy lifting, to go through the emails and the evidence, but ultimately have human judgment. Otherwise, it's likely to be unfair.
Actually,
Okay.
It struck me that AI is likes to be optimistic when you ask it a question, doesn't it? It's sort of
it tells you what you want to hear.
Exactly. So people who want their grievance, to succeed, AI is going to tell them it's likely to succeed. I'm sure an employment lawyer told us that actually on a previous report about this. But I was also thinking actually that I was thinking back to Darren's example on fire and rehire, that the spread of AI makes cases like that far more likely, doesn't it? Because people are going to be needed for fewer hours. I mean, just this week we had Accenture linking promotion to use of AI, but people that didn't use its extremely expensive AI tools from Anthropic or whatever were not going to get promotion. They were monitoring how much people were using. I mean, there's all kinds of issues here for employment lawyers. I mean, where are we going exactly with this?
I just want to speak up in favour of humans doing some of the heavy lifting on investigations, because I've done a fair few investigations in my time. And the thing, if you're reaching a conclusion about an investigation, is you have to be absolutely on top of the facts. And if you delegate to AI putting together a chronology or going through the emails and figuring out whether one email conflicts with another and figuring out how this incident has developed over time or how a relationship has developed over time, if you rely on an AI summary of that and you don't do the heavy lifting yourself, how much are you really internalizing the knowledge of what's going on? And I know when it comes to training lawyers, more junior lawyers as well, there's a concern that the tasks that traditionally a more junior lawyer would do around working out chronology in a case or reading the cases that put together a skeleton argument, and all of the work that they would do in getting a case ready. That's how you learn how to be a more senior employment lawyer, right? That's how you learn the subject. So if you get AI to do it for you, and what you're doing is putting together the AI results that you've got and maybe checking a few things, are you really learning anything? I think we're in danger of de-skilling ourselves.
Yeah, similar on that line. PwC, I think they reined back AI, haven't they? On entry level roles, there was a lot of concern that entry level roles are going to disappear, and they suddenly realised that exactly. So 5 years down the line, they won't have managers of sufficient caliber if they continue on this line with entry level roles and replacing them with AI, because who's going to be there to make the big decisions later? I mean, we were talking about this earlier, and there are reports that AI can actually lower people's intelligence because you're no longer thinking curious, with any kind of inquisitiveness. You're relying on being told all the time. I see it actually amongst my friends even.
Very interesting. Okay, let's move on now. Last week, any HR professionals in our audience who deal with industrial relations on a regular basis will not have failed to notice reforms to trade union rights. Changes include simpler information on ballot papers and notices of industrial action, a reduction from 14 to 10 days notice for industrial action, and the removal of the 40% support threshold in important public services. There are more changes, and you can read all about them on personneltoday.com, but frankly, there's not much to discuss. The rules have changed largely because the government, through the Employment Rights Act, has repealed most of the Trade Union Act of 2016. Governments can do that. They can repeal laws they don't like. And Reform UK, who are, of course, riding high in the polls, have said a couple of things this month that have shocked people. Adam, tell us more.
Well, it sort of started off last week with sort of working from home comments. But I think the big one this week was education and skills spokesperson, someone called Suella Braverman. I've never heard of her. Oh, yeah, she was a Conservative minister, wasn't she? And she said that, in very Trumpian style, she said that on her first day in government, she would abolish her equalities brief and repeal the Equality Act. It sort of immediately reminded me of Trump saying that on his first day he would end the Ukraine war. But it just comes across as something very shocking that someone would say. Interestingly, on Newsnight, it wasn't Suella who was answering the questions. It was Zia Yusuf who said he's going to be Home Secretary under reform, I think. He was unable to sort of describe which protected characteristics Reform UK wanted to get rid of, because every time Victoria Derbyshire put one to him, protection for against discrimination against disabled people, for example, he said, "Oh no, we're going to keep that. Discrimination against women in the workplace. Oh no, we're not going to have that." And then so she said, "So how are you actually repealing the Equality Act? How are you going to repeal it? Because you seem to want all these things." But it boiled down to white working class boys. He said that the Equality Act has no measure in it for social class. And he said that if you come from a minority background, an ethnic minority background, but your parents are millionaires, you'll go to the top of the list. And the Equality Act, he said, is industrializing discrimination against white working class boys.
Okay,
and, so obviously that's met with quite a strong response. He wasn't really able to back it up. He did mention something about the RAF case a couple of years ago. I bet Darren will remember it, when an RAF recruitment did stray into positive discrimination as opposed to positive action. But it was the only example he cited. The RAF were found, the Employment Tribunal found against the RAF because they had been ignoring people from certain backgrounds.
Okay.
But it was a strange interview in many ways.
Well, and Sakir Starmer has said he finds the proposal shocking. Other people have said it's a license for racist and misogynist views.
Yeah. I mean, Harriet Harman was behind the Equalities Act, and she said, it's the legal guarantee that you can't be sacked for being pregnant.
Yeah.
And I mean, the Equality Act goes right back to the Equal Pay Act of 1970. So it's quite a long. It's not a new thing. It's an established act which covers a lot of laws back into the early 70s. Sorry, Darren.
Go on, Darren. You tell us what the Equality Act is. And
yeah. Do you know what? I do have some opinions about this. I think, first of all, there's something about the Equality Act that triggers people in a really odd way, as if it was doing something incredibly new and radical. And I'm old enough to actually remember being a grown-up when the Equality Act came in, and I was giving webinars and training courses on the Equality Act. And the thing that we struggled to do was point out new stuff, because what it was really doing was putting together existing laws. As Adam said, you had the Equal Pay Act from 1970, the Sex Discrimination Act from 1975, the Race Relations Act from 1976, Disability Discrimination Act was 1995. Then we had a flurry of regulations around the millennium on religion, belief and sexual orientation. We had age discrimination regulations coming in 2006. We had European Court of Justice cases that dealt with things like pregnancy and gender reassignment. But by the time you get to 2010, all of those are in place. There were no new protected characteristics introduced by the Equality Act. It was just taking all these different provisions and coming up with a sort of single track.
It was tidying it all up, basically.
It was tidying it all up, in some areas more successful than others. I defy anyone to read the provisions on equality of terms, the equal pay provisions, and say that they've been tidied up. That's not how they read. But by and large, it was tidying it up. It did very little that was new. Some on disability, most of the rest of it was absolutely the same. And I think people also misunderstand positive action and think that employers are able to do more on positive action than they can. Mm-hmm. The provisions on positive action, section 158 and 159 of the Equality Act, are incredibly limited, particularly for employers, particularly if they're looking at recruitment and promotion. And the RAF case, which I remember vaguely, I don't remember whether it got as far as tribunal or whether the government legal service intervened and reversed the decision that had been made. The problem comes because what positive action sort of expects you to say is, we will take measures that will make it more likely that we can recruit people who are from an underrepresented background. So let's say you need more women fighter pilots. I've got no idea whether that was what the case was about. So you might have a target of, well, let's get 25% of our applicants to be women.
Yeah.
Or 25% of our new fighter pilots to be women. And what the law expects is that you'll achieve that target by removing barriers, not by choosing women over men. And I think the problem with the RAF case was that if you tell a military person that there's a target, they take a much different view of the importance of hitting the target than a non-military person does.
Yeah.
So they really went, well, if that's the target, that's what we'll do. When they started going further than the law actually allows them to go.
Right.
You're not allowed in under the Equality Act to say, well, this job will go to this underrepresented group, or we will make sure that 25% of our new people are from this underrepresented group, and we will therefore exclude people who are not from that underrepresented group. You have to make the decision based on merit. I think there's an argument for widening that in some circumstances, but the Equality Act as it stands is very restricted in terms of what you can do for positive action.
So Darren, in terms of reforms plan on day one to repeal the Equality Act,
that's not going to happen, is it? You don't get to just repeal an act on day one.
Would it be like Brexit?
You can't just write a letter.
Or maybe they'll do.
You've got to repeal the act.
Maybe they'll do it within 100 days.
But I can't understand. Suella Braverman was in the Conservative government. Her anger about the Equality Act was completely unknown during that period. I never heard of this before.
Yes. I mean, it's if there is no way anyone is going to just repeal the Equality Act, right? You could limit it. You could think up things to reform on the Equality Act. You might look at some of the issues that the Equality Act presents.
They could
and
look
if you
at
look
social
at it from
mobility as a protected characteristic.
Well, actually, I think that's perfectly reasonable, because
chucking the whole thing out.
The reason it's called the Equality Act as opposed to the Discrimination Act was that part one of it, which the Conservative government didn't implement, was imposing a duty on public bodies to have regard to socioeconomic disadvantage.
Yeah.
And I think there's a perfectly reasonable argument to be made for making socioeconomic background a protected characteristic. I mean, it would be a radical change. There'd be all sorts of implications to it, but I think that would be an enjoyable process to debate and watch that roll out.
Yeah.
And, I think I might do well out of that. So,
yeah, I think Victoria Derbyshire, she wasn't quite sure of her ground, but she did say, there's very limited scope on positive action. She tried to make that point to Zia Yusuf, but he simply said, "Oh no, we don't think there is." So he wanted people to think that positive discrimination was absolutely rife and rampant, and that DEI was rampant.
To blame.
Yeah, and of course,
yeah, but there's just no link between.
Back.
There's just no link between the vibe that they're putting out about what positive action is and what DEI is, and anything that's written in the actual Equality Act.
Exactly.
And as someone who's concerned with what the Act actually says, rather than vibes about what the Daily Mail might write about positive action measures, I think we should focus on what the Act says. And I think you'd struggle.
Suggesting they haven't read the law?
Do you know, I think it's possible. I think it's possible that when they decided that they were going to repeal this, they didn't actually know what was in it. I think, we have to engage that possibility, I think.
I think at this point, it's worth mentioning that Jacob Rees-Mogg was the next person that she spoke to. And he was asked about it as well. And he said, the Equality Act is a dreadful piece of legislation because it goes away from the principle that we are all equal under the law. But of course, he's confusing equal under the law surely with equal treatment under the law. I would have thought. I'm not a lawyer.
Yeah, I mean, it's gibberish. What he was saying was gibberish.
Yeah.
Right. It's just, and it really irritates me that people get to just sit on something like Newsnight, make stuff up about what the Equality Act says, and everyone has to sit and nod along like they're not just talking utter nonsense. And you can take a political position about the use that non-discrimination laws have or anti-discrimination laws have, right? If you've got a political position that you think employers should be allowed to discriminate on various characteristics, then by all means set that out. But let's not start off by pretending that the Act says something other than what it says, and then and base our plans based on that misunderstanding, right? If you've got a position, set it out and let's have that debate. Let's not just make stuff up.
Yes.
Okay.
That seems to be the approach to try and divide people by making out that something's true that actually isn't true.
Yes, and it's much easier to repeal something that doesn't exist.
Yeah.
It's sort of, you can, if you focus on a problem that doesn't exist, it's much easier to solve through legislation, because once you've legislated, you can point out that the problem doesn't exist anymore. Yeah. And the people who are saying, well, it never did, just don't get listened to.
Yeah.
Well, we will see in 2029 whether we're still talking about this topic. Okay, that's all we have time for. Remember to subscribe to this podcast wherever you get your podcasts. And if you're interested in taking part or want to share something, do drop me a line by emailing rob.moss@personneltoday.com. Our next episode will drop on the last Wednesday of the month, so that will be the 25th of March. The Personnel Today HR podcast is brought to you by Deal. Hire, manage and pay anyone, anywhere. Thanks for joining us, and thanks Joe, Adam and Darren for all your contributions. Thanks.
Thank you.
Goodbye.
Cheers, everyone.
Bye-bye.
Goodbye.